I don't have a gavel, but I'd like to call the ZBA meeting to order. It's about 7 p.m. here on May 18th. The first thing we'll do is pledge allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We've got 4 members here, so the first thing I want to do is, we had an October 20th meeting that we never approved, as we hadn't had a meeting since then. And now I've gone through all the minutes myself, and everything seemed fine. And has anybody got any amendments to the meetings they want to make?
I wish my memory was that long. No, I looked at him.
Huh? Peyton?
No.
Huh? Well, we need a motion to accept them.
Motion to accept the meeting, the minutes of the meeting of October 20th, 2008.
A second.
All in favor?
Aye.
Aye. Yes. Now, the first one we got coming up is with Linda Rasek, and I'll have to appoint Mike Provo as a sitting member on this case. The code enforcement officer will read the case.
Mr. Chairman, the first case before you is a public hearing for a special exception, reference section 7.03 of the Newmarket zoning ordinance. The applicant requests a special exception to permit an accessory apartment. The lot is located at 29 Ash Swamp Road, tax map R3, lot 17-1, zone R1, and John Redcheck is here this evening.
Would Mr. Rasek come up and present his case to the board?
I'd just like to say that first off, this is strictly for my mother-in-law. That's the reason why we built it. So as soon as she passes on, we're gonna convert it back to the make it part of the main house again. So that's basically the only statement I really have to make about it.
Now, I'll read the 7 criteria, and you have to answer yes or no to them.
Okay.
And if it's no, we have to know the reason why, and if it's yes, we do. The accessory apartment shall be a minimum of 300 square feet and a maximum of 800 square feet of finished living area.
Yes.
Is it less than 800 or more than 800?
No, it's like 802.
So that's part of that's the upper story then?
Well, what happened was we put the addition, used to be our old kitchen. The house is about 215 years old. And what they did is it was kind of weird because the plumbing, like all the plumbing was underneath the main house, and then they built the kitchen, I guess later on, whenever. They built like a 6x4 tunnel underneath the house, and then they put like a big square earthen box that they dug out underneath the kitchen where all the pipes went up. And so when we excavated to try to pour the foundation, we couldn't pour it exactly where we wanted to because the guy was afraid that because it was all just big, huge stones, it's not real a concrete foundation, it was just basically stacked stone. So he didn't want to put the foundation where it would have been actually a little under 800 square feet. We had to move it. It was either 8 feet one way or 2 foot another, and my mother-in-law was, she was paying for it. So we went the greater distance because she wanted a little more living space. So that's why it's a hair over 800 square feet, because of the way the foundation was when we dug it out.
Now, the over 800 square feet is not negotiable, so I'll ask the code enforcement officer what we can do about that. He's got to either ask for an equitable waiver to go a different route, or he's going to have to reduce the size of that apartment. Is that correct?
I think you could probably take a blank wall that's there now and put additional framing on that wall to reduce the size to
I have no problem doing
800
that.
square feet.
Okay, so you can meet that criteria?
Oh, yeah.
Okay.
Yep.
I can verify that, Mr. Chairman.
Okay, you'll be checking.
Yes.
Okay.
The accessory apartment shall either be an efficiency apartment without a separate bedroom or a one-bedroom apartment,
It's a one-bedroom.
okay? One of the dwelling units must be owner-occupied.
Yes, that's us.
There shall be a minimum of 2 parking spaces for each dwelling unit. A parking space shall be defined as a rectangular space, 9 feet by 18 feet. Parking spaces shall be permitted within the setbacks if the location is over 50 feet from abutting dwelling units.
Yes,
I know you read that. No exterior changes shall be made which significantly alters the appearance from the street.
yes,
Adequate water supply and sewage disposal shall be provided. If town water and sewer services, the site tie-in fee shall be paid.
yep.
You're on well and septic
Actually,
system.
we're on town water, but we have our own septic system.
Now, I think there's a tie-in fee for the accessory apartment, is that correct, Dan?
No, there's not. He's still using the same meter.
The same meter?
Yes,
So he's all set there?
yes.
For septic?
No, the septic is a different
For the water.
thing. Now, how about the septic system? Had it be pre-approved?
We really don't stipulate here. If you were buying a new house and it was a 3-bedroom home and you wanted to convert it into a 4-bedroom home, the state would say to you, provide me with a plan that in the event that your 3-bedroom home septic fails, that you can immediately go to a newer system in hand. Here, we don't discuss that
Right.
as being part of the requirement. Certainly, the board could request that, I think, as part of the approval requirement.
Granting of the special exception would be consistent with 1.05A2. You meet all of that. Now, he pretty much meets it, but we've got to make a couple of adjustments here because he's going to have to reduce the size of his property to less than 800 square feet. And do we want him to have a septic design? Current one set up for the septic system or not? That's up to you, the board.
I'd just like to say that our original house was a 4-bedroom house, and I removed 1 bedroom it's actually living, it's like a living room now.
Yeah,
So I actually removed walls, and we have a complete open space floor plan downstairs. So the bedroom that I added on, I'm still at 4 bedrooms, I guess is what I'm trying to say.
yeah, you haven't increased any.
Right, I haven't increased the
Interior.
bedrooms. I had 4, I took 1 away in the main house, and then added 1 on in the accessory apartment. So my bedrooms are exactly the same as they were before. So, but I can do, I mean, if you want to, it's up to you. If you want to plan,
Yeah,
I have no
it's up to
problem
the
with
board. It's not just
Yeah.
up to me, it's up to the board.
that. Right,
Yeah.
Mr. Chairman,
Yes,
he meets the state regulations, he meets state law with a 4-bedroom septic and a 4-bedroom home.
okay.
And I would think that the board would be overstepping their jurisdiction if there was an additional requirement to a septic system.
Well, then I think we should approve this with the condition that the living area be reduced to less than 800 square feet. That sound reasonable then?
I have one question. Where it says here, accessory apartments are permitted in certain districts, what are they trying to refer to there?
It's in the R1 district.
It's in a permitted area.
It's in a permitted area.
Okay, I'm reading 703A, it says, purpose accessory apartments are permitted in certain districts. I just wondered what they mean by certain
If we
districts.
go back to 1.05,
Yeah.
nonconformity,
Yep.
expansions of a non-conforming use. For instance, downtown, apartments are not permitted on ground level, at storefront level. So that would be one reference to where an accessory apartment may not be permitted in the C1 zone.
So they're permitted, except where they're not permitted? then?
Correct.
Okay.
Exactly.
Does the board have any other questions? Yes?
Hey, it's been brought to my attention that there's some possible issue and conflict over the timing of how long has this been used as usually I think you get a permit before you precede? It sounds like this has been in use, and now you're seeking a permit after the fact.
I came in front of the, the board and asked them, I told them what I wanted to do, and they said, as far as I was, I told them what I wanted to do is for my mother-in-law, I said it was strictly for my mother-in-law when she passes away, that we're just gonna convert it back to for the main house. And they said, well, go ahead and build it, and then after a year, come back and get your special exception.
I don't think you got it from this board.
No.
Not from, I was on the
No.
board when you came in front of us in 2003.
Right.
And you wanted to put the apartment in the garage. And we,
I can't, yeah,
And
and
we
I can't, I
denied
think
that.
that might have been my wife.
well, whoever came, but
Right,
we
right.
denied that application.
Right, so we did, no, right, so this was a completely different, we decided to tear down, because we couldn't, obviously we couldn't do it over the garage.
Right.
That we decided to tear down part of our house and build it there.
Yeah, because I can't remember whether you or your wife.
Right, and,
presented
yeah,
it
I know,
in
because
2003
but we
when
did
I
get a
was on the
building
board.
permit to do
Huh?
it. Is that what you mean?
No.
Oh,
no,
oh.
A
Oh.
permit to do what you've been doing it for is an accessory apartment. I understand in the past that it was done, as you are suggesting, a build something, and a year later, people would try and come back, and since it requires the existing footprint of the house to put a accessory apartment in, then they would come back and say, well, this is already here, now we're requesting a permit for accessory apartment. But if you did as you said, it wasn't this board, it must have been several years ago that this happened.
That
that you got
I
the
can't,
advice to
give
do
you the
what
specific date,
what
no.
you did do.
Because we built, I can't,
You didn't expand the size of that house at all.
no.
No, he's still in the same footprint.
Right, I'm still in the same footprint, right, I just tore down existing house and obviously, put a new foundation, but the foundation is where the old foundation was.
Okay.
But it's poured concrete.
Well, then how long has it been used as an accessory apartment?
When did she move in? At least about 3 years, yeah.
I think that's our problem. We don't understand. You needed a permit to put in an accessory apartment, but you've been using it for an accessory apartment for 3 years, and now you're coming to us for the permit. That's what's confusing us.
Well, all I can just say is it's my fault for not doing it as soon as I should have. Started having kids and everything slowed down. I really wasn't actually done. It took a while to finish that place off, and I'm still working on it. I'm still doing the outside siding. So once we started having children, everything just kind of, it just slowed right down to the point where I wasn't even, like I said, I'm just now getting the outside wall, one of the last outside walls done. So it's just my fault for not coming as soon as I should have, or maybe getting it finished as fast as I should have. So for that, I apologize, but there was no.
So when you got the building permit, you didn't tell the building department you were building an accessory apartment.
He didn't get a building permit.
Oh yeah, I have a building permit.
Oh,
Yeah, there's a building permit for that.
But if you'd have told them it was an accessory apartment, they would have sent you to us. And this is the first we've seen you.
Well, I can't. I'll be honest with you. I can't tell which direction it went. If I came to you guys first and then got the building permit, or if I got the building permit first and then came to you guys.
Well, you didn't come to us, or you wouldn't be here now, I think.
Right. No, I'm saying when I talked to them about what I wanted to do, and they told me to.
Or you're looking at the building permit person right over there, and he wears two hats, so.
Mr. Chairman, if I could comment to this.
yeah, yes.
The house originally had a kitchen. John built a new kitchen, and rather than eliminate the first kitchen, he remodeled the first kitchen, now having two kitchens. I think it's sometime in between that actually happening is when he came to the board for an accessory apartment. And I think at the time, the accessory apartment, as the ordinance speaks, is permitted in a existing structure.
Right.
So some time ago, we had to make a determination as to what was an existing structure. The planner at that time made a decision saying that if a structure has been up for a year and an applicant came forward and requested an application or a special exception for, a special permit use for an accessory apartment, that if that structure has been up for a year, then it was considered an existing structure. I think the applicant was probably in, and I can't say this for sure, but from his comments, I do remember him coming to the board for the apartment over the barn that was in the back, which was not detached to the existing structure as it is now. And I think at that time there was some conversation about come back in a year, and now that you've come back in a year, now that you can apply as that accessory apartment being in the existing structure. So I think, matter of fact, I know if the kitchen was in the same location as when you started that project, that the new kitchen became completed and the second kitchen was never eliminated, nor did the applicant come forward to the board for the request for the accessory apartment. How the applicant got here this evening was that an appraiser had visited the property and came and reviewed the historical records that were on file in our office and determined that, and commented and questioned whether or not the accessory apartment had ever been permitted. Our response was no. We advised John to move forward with the application and present the request to the board.
So in your opinion, this was a good faith mistake or whatever?
I think so.
I think that happens a lot,
Yeah.
you know, that people can misinterpret something and then.
Do we have to send out to abutters for this?
I don't think.
Is there any abutter notice for this
We
requirement?
have to open it up to the abutters.
The abutters notification, yes.
Yeah,
Has that taken place?
Yes.
Okay.
yeah, they do all of this, yeah. Now, is there any abutters here that would like to speak for or against this application? I don't see any, so I'll close it to the public hearing of the abutters. Now, we gotta have some kind of a ruling on this, either we approve it or we disapprove it. I think we should approve it.
With the 800
with
foot
the square footage being less than 800 square feet, and leave that up to the code enforcement officer to determine when that's done before the final approval is taken.
And this is a temporary use,
And
right?
it's a temporary use, as for the
Yeah,
applicant.
and this will be a temporary apartment for his relative.
Well, still has to meet the,
Does that work?
still has to meet the 800 feet, though, right?
Right.
Oh,
Yeah,
that's
they're
true.
gonna reduce the square footage to less than 800 square feet, which is the maximum.
Are you looking for a motion, Mr. Chair?
Yeah.
I'd like to,
The guy has broken the law.
Well, not according to the code enforcement.
I would like to
He said
entertain
he
a
thought it wasn't
motion, Mr. Chair, that we approve the request before us under the condition that, two conditions, that the size of the unit be reduced to 800 feet by, or less by
Any method.
any method that's approved by the building inspector, and he will verify that. And the second condition would be that it is a temporary approval for the use of your family at this time, and when that approval, that use is no longer needed, it will revert back to a single-family dwelling.
We have a second?
I'll second
We have a
You
motion?
can say. I don't think we can establish that.
that. You know, don't think we can.
After talking to Jane.
We got so much stuff going. I'm saying that he broke the law.
Yeah, but there's no penalty assigned to it. Not on a monetary figure, unless the council can set a law up for it.
Can't even make him say 3 Hail Marys.
Yeah, we can do that, go to church on Sunday. But we have a motion and a second. Now we've got Erica, would you call a vote?
Scott Glenn. Michael Forbes.
Aye.
Keaton Park.
Aye.
Mike Watson.
Aye.
Richard Chapman.
Aye. Now you're all set until, and Dan will have the final say on the final approval,
Okay,
okay?
thank you very much.
Yeah. Now, There's no way to stand the same. Now, I think, I think it's the
Yes,
paperwork.
yeah, I agree.
Now, we're gonna have the second case with the Cheney case, and I'm gonna have to recuse myself, and Peyton Carr's gonna take over, but we may have to take a few minutes breaks until the other members come down from upstairs. So I think we should take a break when they come down, because we'll need 5 members. And I'll recuse myself.
Mr. Cheney?
Do we have to do that during the session? Do we have to do that in session?
Can
or
we
do we-
move the table over there so that we can sit at the table rather than standing up there and home paperwork and stuff?
Where would you like it?
Do we recuse, do we have to do that during session?
After he takes over.
Yeah,
After
we
he
don't
takes
want
over.
to. Let's turn it
We
around.
have it open, I just gotta step down, I can't, once he opens it up, then I think after he opens the case, then
Wait till the
recuse yourself.
second session.
After, I've gotta step down because I can't get it all.
All right, if I can have your attention, please. It looks like we have our missing member.
My
and
apologies.
And we can proceed. First order of business is, involves recusals. Would anybody like to recuse him or herself?
I'm a resident of Moody Point. I think I shall recuse myself.
Thank you. Would you like to,
I'm in the same position, I'm a resident, I'm in a butter, so I'm going to recuse.
okay? Would you like to move to the less comfortable audience?
And we need to vote to anything before you, because when we leave, you don't have enough people to get the alternates on board, or
No, I
can
don't
we
think
just
there's
get
any
them
voting.
Who's David? Oh,
He's in the
David.
back. As I am now the acting chairman, and since we have actually 3 recusals, with Chairman Shelton recusing himself, I'm going to reappoint Mike Provost, and we also need 2 more. Looks like David Bird and Dana Glennon need to come forward, please.
Thank you.
Dan, would you like to read the application, please?
I will. Mr. Chairman, the application reads, Walter W. Cheney. Public hearing for an appeal from administrative decision. The applicant requests an appeal from an administrative decision to allow for the issuance of a building permit, the application for which was denied due to the lot being determined as unbuildable open space. The lot is located off Cushing Road, tax map R2, lot 36-13, zone R1. And Mr. Chairman, this evening, the law firm of Mitchell Municipal Group will be representing code enforcement this evening, and Mitchell will be represented by Laura Spector, if you please. Attorney Laura Spector.
Okay, thank you.
Would you like to see you?
Oh, I'm right here.
All right.
But you want me up there?
Welcome.
Thank you.
Normally, the ZBA hears from the applicant first. However, in this case, unless the board objects, I would like to have our counsel, Laura Spector, who is representing the building inspector, discuss what issues she has to raise.
I do
That's-
have a brief procedural issue, if it's okay if
The
I raise that.
applicant
Yes.
agrees to this.
And just to be clear, I am representing the Code Enforcement Department this evening. I am not representing the zoning board, and I just want to make sure you understand my role. I have for you a binder of materials, and I apologize for not getting it to you earlier. We were actually putting it together right as I left the office today. I have one procedural issue and one point of information I just wanted to raise for the board to do with what it likes. And that is, I don't believe this board has jurisdiction to hear this appeal. This board has jurisdiction to hear matters that fall within its purview under RSA 674-33. And that relates to matters that involve the enforcement or the interpretation of the zoning ordinance. So if a matter does not involve the interpretation of the zoning ordinance, that is, if a building permit is not denied based on the zoning ordinance, this board has no jurisdiction to hear an appeal about that denial of the building permit. In this case, the building permit was not denied based on your zoning ordinance. It was denied based on the approval of the subdivision back in 1985, based on the regulations that were in place at that time, and based on representations that were made to the board at that time, and at subsequent amendments to the plan. So the first issue I raised for you, and it's set forth briefly at the beginning of my letter, at the beginning of the binder, is that this board has no jurisdiction to hear this appeal, and I would encourage you to dismiss the appeal on that basis. The other piece of information I just want to bring to your attention is that there's a dispute as to who is the owner of Lot 13. The Moody Point Community Association has, as I understand it, on Friday, filed a petition to quiet title with the Rockingham County Court to require that Mr. Cheney convey Lot 13 to it. It feels that based on these representations and based on the regulations, it is the rightful owner of Lot 13. Now, were I advising this board, I will be completely honest with you. I would tell you this is a private dispute and you should stay out of it. But as I'm representing the Code Enforcement Department, I will tell you if this board is inclined to stay these proceedings until that litigation is resolved, we have absolutely no objection to that. So I would encourage you to discuss and resolve these two procedural issues, perhaps after Mr. Cheney has had a chance to respond to them, before we get into the merits of the application, because there's not really any need to get into the merits if you're going to dismiss it for lack of jurisdiction. Thank you.
Okay. Mr. Cheney, would you like to respond?
Yes, I certainly would. First of all, Laura could have presented that to begin with. In other words, I think, well, first, can I ask Dan some questions? Is that appropriate?
You should be responding to Laura, I would think, first.
I would think so, yeah.
Okay.
Stop me if you...
Dan?
No,
could
you
you-
should, yeah.
Just as a point, I think we need to deal with what Laura has
Yes.
presented to
Yes.
us first, and that you would need to rebut what Laura's saying or something else at this point in time so that
Okay.
this board can make a decision. Just a suggestion that I
Yeah.
have.
Right, and I would concur with that.
That leads to that. What my understanding that Dan was instructed by Laura to draft the letter that I received that states that my building permit was denied, says it has been determined that Lot 13 is unbuildable open space. Okay? She had every right to present what she's presented here tonight at that time. She wouldn't have wasted any of our times. Okay? She's had many opportunities I've sent many letters to her. I've offered to meet with her to discuss all these issues. She has refused to meet with me or correspond with me. So my concern is she's had many of our opportunity to do this in writing prior to tonight. I'm done.
Okay.
Maybe Laura Spector couldn't respond. Was it tied into the suit that was brought by Moody Point on Friday? Was that the suit questioning the ownership of the piece of property?
She has knowledge of a suit that I have heard about, but she claims that she's received actually information. I believe by law, I'm supposed to receive information if there's a lawsuit filed against me. I have no such information as of this time.
Mr. Cheney will be served with notice of the lawsuit once the court has had the opportunity to prepare the orders of notice. I did get a carbon copy when it was filed with the court from the attorneys who represent the Moody Point Community Association. I'll also point out for the board that I have responded on occasion to Mr. Cheney's request for additional information. However, in my opinion, he was requesting the same information over and over again, and I declined to provide that information over and over again. I will also tell you that I did not instruct Mr. Vincent to do anything. We discussed Lot 13 and the matters which may or may not make it unbuildable. We believe it makes it unbuildable, and based on our discussions, he determined that the lot was unbuildable and issued his decision.
Mr. Chairman.
Yes, sir.
I will concur with that synopsis. You notified him more than once because members of the ZBA board as well as the council had previously received your memos, I believe, so. Okay?
Mr. Chairman, I'm under the opinion, not only this lawsuit, but there's a lawsuit with the town involved in this. Is that correct or is that incorrect?
I believe so.
They're all.
If I may, there is a lawsuit appealing the planning board's decision that the conditions of approval of a subdivision of Lot 13 were not met.
So given that this is under litigation, not once, but now going for a second time, in essence, we're putting the town ahead of the jurisdictional requirements of the court system in order for us to determine properly after the courts have adjudicated. Am I not correct? I'd like to make a motion then.
And if I may just clarify something, first you have a comment from a member of the board, but I also just wanted to clarify that the buildability of Lot 13 is not directly at issue in any of the lawsuits.
I just, from having been on the board previously and for a while, I believe that state statute requires us to know that the person before us is the actual owner or an agent in writing for the owner of the property. As a member of the board, I feel rather uncomfortable with the knowledge that there is a question of the actual owner of the property that's been brought before us. At that point in time, I feel and would suggest that we really cannot hear any arguments on this evening until such time as an actual owner of the property is determined. If it's in litigation,
Is that your motion?
You know,
That is a motion.
I agree with what was just stated, and I'd like to make a motion that we postpone any discussion on this issue until the lawsuits have been properly adjudicated and we have legal answers in front of us by which we can then render a decision.
And I will second that.
All right. Do we have a discussion?
you also have a question.
Question? Go ahead.
I have a deed that shows that I own the property. Anyone can walk into any meeting and say somebody doesn't own something. I can say you don't own your house, you don't own your house, you don't own your house, right through the list. I have a deed that says my property. I've owned it since 1999, okay? How many people have ever showed up here and said I didn't own it since 1999? This is some sort of a game everybody's playing here. Prove to me, I can prove right here tonight, if you want to give me the time, you have an attorney here, I will prove to her tonight I own that property. Give her every right to defend herself, and you can be judge and jury.
And just to be clear, I'm not saying he doesn't own it, and I am not encouraging this board to make its decision based on that. It's just an issue I wanted to bring to your attention. If the board's going to make a decision to dismiss it, I would much rather have you make it on the jurisdictional basis.
Yeah, that's what it is, jurisdictional.
I don't think the ownership is in question here. I mean, it is in question, but I don't think it's pertinent.
That's not the basis of
decision
the
that needs to
motion.
be made tonight.
Yeah, it's not the basis of the motion.
Is there any other discussion on we have a motion
Yeah, and second.
and a second?
Roll call.
I'll withdraw. I can withdraw the motion. I don't have a problem doing that.
He made the motion.
Dave Bird made the motion.
Dave made the motion.
Yeah. So,
Roll call, please, Erica. You want to read the motion again?
Read the motion. Erica?
Motion was made by David Byrne to postpone discussion until the lawsuits against the town are adjudicated and the board has legal answers. Motion was seconded by Dan Glenn.
Okay.
I can't advise you.
Okay. Oh, that's right.
roll call. Oh, you're doing roll call.
Roll call, please.
Roseanne Fox.
Aye.
Janet Lennon.
Aye.
David Byrd.
Aye.
Michael Provo.
Aye.
Peyton Carr.
Aye.
Motion to adjourn.
Motion to, do I have a second?
Somebody want to second the motion to adjourn?
Since I'm going to appeal,
Okay.
do I go directly to court?
I can't advise you.
Okay,
Ask your attorney.
I am the attorney.
You are the attorney.
Well-
Then you need to read up on the RSA of it. so-
Okay. Yes.
That's what I'm saying.
And I am curious. I come before the council, I come before this board. Everybody wants to talk to me in court. Doesn't make any sense to me that as a citizen of the town, I want to come and meet. I can't meet with the town administrator, I can't meet with the council, and I can't meet with legal counsel. So everybody wants to see me in court. I promise you tonight, you will have many court cases to deal with. It makes no sense to me as a community why you want to be put in that position, but clearly that's where you want to be.
Was there a motion?
There was a motion to
Do we have
adjourn.
a
I made the
second?
motion.
Second.
All in favor?
Aye.
Aye.
Opposed? So,
Thank you.